Thank you, General. General Campbell.
Mr. Chief Justice, and may it please the Court. The Secretary is attempting to bypass Congress on one of today's most debated policy questions, student loan forgiveness. After many failed legislative efforts, the Secretary seeks to write off nearly $500 billion in loans for over 40 million borrowers. No statute authorizes this sweeping action. On standing, Missouri has the right to vindicate the harms to MOHELA. MOHELA is a state-created and state-controlled public instrumentality that performs the essential public function of providing financial aid to Missouri students. The Secretary's program threatens to cut MOHELA's operating revenue by 40%. That will directly undermine MOHELA's ability to further its critical public purposes, and the state has standing to assert those harms. On the merits, this is a major questions case. A nearly $500 billion debt cancellation program is undoubtedly a matter of vast economic and political significance. It is also unprecedented. Never before has the HEROES Act been used to forgive a single loan. In addition, the Secretary here asserts a breathtaking power to do anything that he thinks might reduce the risk of borrowers defaulting even years after a national emergency arises. He needs clear congressional authorization for such power. But he doesn't have it here because the HEROES Act does not authorize this program. The Act permits the Secretary to waive or modify existing provisions because of a national emergency. It does not permit him to rewrite existing provisions to create a new program that covers 95% of borrowers and applies to them regardless of how the pandemic affected them. This Court should declare this program unlawful, and I welcome the Court's questions.
General, I think at the beginning you should comment some on the relationship between MOHELA and the state of Missouri. Primarily, as you've heard, the effect of this forgiveness program on MOHELA and by extension on the state of Missouri for the at least to establish standing.
Sure, Justice Thomas. To start with the effect on MOHELA. So MOHELA, approximately as of last fiscal year, 77% of its operating revenue came from servicing direct loans. The Secretary tells us that nearly half of all borrowers' loans will be discharged under this program. So it stands to reason that about half of MOHELA's operating revenue from direct loans will be cut, and overall that amounts to about 40% of its operating revenue. Now, Justice Jackson asked the question about whether there are offsetting fees. It's very hard to believe, and the government doesn't offer any details in its reply brief, that a one-time payment of fees for discharging loans will offset the ongoing fee that MOHELA earns from servicing those loans. So
Americans have struggled to pay rent, utilities, food, and many have been unable to pay their debts. To head off immediate harm for student loan borrowers, two secretaries across two administrations invoked the HEROES Act to suspend interest and payment obligations for all Americans with federally held loans. But if that forbearance ends without further relief, it's undisputed that defaults and delinquencies will surge above pre-pandemic levels. So Secretary Cardona again invoked the HEROES Act to provide a measure of loan forgiveness to ensure that this unprecedented pandemic does not leave borrowers worse off in relation to their student loans. The states ask this court to deny that vital relief to millions of Americans, but they lack standing to seek that result. They principally assert harm to a separate legal person, MOHELA, that could sue in its own name but has chosen not to do so. And the states' asserted harms to their tax revenues are self-inflicted and indirect. The states' bare disagreement with this policy is not the sort of concrete injury that Article 3 demands. On the merits, the states say the act doesn't authorize the Secretary to ever forgive loan principal, but the Secretary's interpretation of this text is not just a plausible reading, it's the best reading. Congress expressly authorized the Secretary to waive or modify any Title IV provision in emergencies to provide financial relief to borrowers. Loan forgiveness is a paradigmatic form of debt relief, and the Secretary acted within the heartland of his authority and in line with the central purpose of the HEROES Act in providing that relief here. To apply the major questions doctrine to override that clear text would deny borrowers critical relief that Congress authorized and the Secretary deemed essential. I welcome the court's questions.
General, is this a waiver or is it a modification?
It's both a waiver and a modification, Justice Thomas. This appears at JA 261. That was the decision document that the Secretary signed where he said, I hereby issue waivers and modifications of multiple provisions under Title IV of the Student Loan Program. And then that language was repeated in the Federal Register notice that actually implemented that program and constitutes the final agency action that the states are challenging here.
Well, could you explain then, in other provisions, there is express language as to cancellation, and of course there isn't here. So would you take a minute to explain how a waiver or modification amounts to a waiver, to a cancellation?
Of course. So the Secretary identified various provisions in Title IV that govern the terms and conditions of student loans and also govern discharge and cancellation in other circumstances, as your question suggested. And I think the straightforward way to think about how the verbs map on to the Secretary's action is that he waived elements of those provisions that contain eligibility requirements for discharge and cancellation that are inapplicable under this program, and then modified the provisions to contain the limitations that he had announced as part and parcel of announcing this loan forgiveness. Now, you had suggested that there's no express statement in the HEROES Act to discharge loan principal, and that's true, but the relevant and operative language here is the provision that says the Secretary is empowered to waive or modify any Title IV provision. And so the HEROES Act isn't enumerating any of the various forms of relief that have long been authorized and implemented under this statute. I don't think anything can be read into the fact that there's no express reference to particular forms of relief because Congress was trying to broadly cover the field and ensure that the Secretary had the tools to respond to the national emergency with whatever relief might be necessitated.
But in an opinion we... Thank you. Justice Thomas, anything further?
Just briefly, there's some discussion in the briefs that going past this provision or that modification or waiver, that this is in effect a cancellation of a debt. That's really what we're talking about. And that as a cancellation of $400 billion in debt, in effect, this is a grant of $400 billion. And it runs headlong into Congress's appropriations authority. And I'd like to give you some time to respond to that.
Sure, and so first I want to take on the argument that some amici have made in this case about implicating appropriations authority. Of course, implementing this program doesn't require that any money be drawn from the Treasury, and so I don't think that it strictly raises an appropriations issue, which is why I think the states aren't raising that argument here. And to the extent that the concern is about the Secretary taking action in a way that Congress didn't authorize, it seems to me that it just collapses back into the central interpretive question in this case, which is, does the HEROES Act authorize the Secretary's action or not? With respect to the concern you raised that the effect of loan forgiveness here will result in cancellation of a measure of debt for the affected borrowers, of course that's true, but I don't think that that is materially different from the kind of effects you can see from other types of authority that's long been exercised under the HEROES Act. You know, take the forbearance policy that I've mentioned. This has been powerful relief for debtors, for student loan borrowers while it's been in place with respect to their debt. And it's had, kind of permanent financial effects on the government, over $150 billion over the course of that forbearance program by the end of it. But it's been absolutely critical relief, and it's provided that kind of help to the student loan borrowers as well, who haven't had to make those interest payments or any payments on their loans while it's been in place. And that too can have the kind of consequence of resulting in cancellation of principal during the period of forbearance. The years that borrowers spent in forbearance count towards loan forgiveness programs, for example. So at the end of the day, those borrowers in income-driven repayment or public service loan forgiveness are going to pay less on their loan overall. It will be forgiven 3 years earlier or without those 3 years of payments that they weren't obligated to make. But I don't think that in any sense calls into question the legitimacy and authorization behind the forbearance policy.
Well, I think that forbearance fits more comfortably in waiver or modified language. It's you simply forbearing on collecting an underlying debt. but you don't cancel the debt, and that's what we're talking about here. And certainly there's a cost to that, I understand. But I still think that you haven't fully explained why, if you looked at this, you would not argue that the Secretary could actually grant $400 billion. So we agree on that.
I'm sorry, outside the context of the HEROES Act?
Yes.
That's right. We, of course, are premising the relief here specifically on the HEROES Act. So you would rely on appropriations from Congress for that, right? Yes.
And the argument is that you are, in effect, doing that without appropriations from Congress.
Well, Justice Thomas, I don't see how you could distinguish that from any of the other forms of relief under the HEROES Act. All of those forms of relief cost the federal government money, and often in significant sums. You know, one of the quintessential forms of relief that the government has offered before in periods of extended deferment for soldiers fighting abroad is to pay the interest on their loans for them. And I think you could probably make the same argument of questioning, well, does that cost the government money? Is there an appropriations overlay there? Does that transform the nature of the program because it takes a loan with interest and makes it effectively an interest-free loan? But that's exactly what Congress intended under this authority. It's to make those changes to the program in direct response to and in direct proportion to the situation the Secretary confronts that will otherwise leave that borrower worse off.
Mr. Connolly, has this court ever held that the notice and comment provisions of the APA can establish are enough for standing in a case like this?
Yeah, I would point to Summers. In Summers, this court held that an environmental organization had standing to challenge the Forest Service's approval of the Burnt Ridge project, and because the Forest Service approved that without going through notice and comment. And that environmental organization had standing because there was some possibility that if they went through the proper process, that the Forest Service would change its mind and wouldn't approve the Burnt Ridge project. And I think it's the same thing here. If the Secretary goes through the proper process, there is some, and does negotiated rulemaking and notice and comment, there's some possibility that he will change his mind and forgive our debts.
Were the procedures in Summers applied in Summers?
Were they implied? I think it was.
No, applied.
Oh, applied. In that case, yes, the court said, the court found it was drawing a distinction between why they would have had standing in one place and wouldn't have in another. And the reason that the group ultimately didn't have standing is because they had settled it. But the court said that if Burnt Ridge had still been on the table, that they would have had standing.